Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
All right, good morning, sir. Are you Mr. Gossett?
That is me.
Okay, calling case number 18-769, people of the Township of White Lake versus Brandon Ray Gossett. Mr. Gossett, you've identified yourself. Counsel, please put your appearance on the record. How would you like to proceed?
Thank you. Good morning, Your Honor. 1-815-1520 on behalf of Mr. Gossett, present via video. I have had the opportunity to speak with him. I've gone over the charge at this time. He'd waive a formal reading of that charge. I'd ask for the opportunity to address bond.
All right, I'll indicate to Mr. Gossett that he is here pursuant to a bench warrant. He's already been arraigned on this matter. He may have already actually pled to it at some point. So he failed to appear. The judge set a bench warrant and a new bond in the amount of $447. So counsel, I'll listen to your argument with respect to bond.
Thank you, Your Honor. So the court covered it, but I think this is a charge that my client's already dealt with. It's just that he owes the court money. He does not have the money for bond right now. It's set at $447. This is a driving offense. Michigan law does require essentially that the court allow a 10% provision for driving infractions and non-violent misdemeanors. I would ask that if we're unwilling to give them a personal bond, which I'd ask for initially, that we add a 10% provision onto the interim bond. And that's what we would ask for, Your Honor.
All right, appreciate the argument. I think the bond is reasonable asset to ensure Mr. Gossett's appearance. I don't think a personal bond is appropriate, so I'm going to continue the bond that was set by the judge in this matter. $447, cash surety, no 10% without previous conditions to continue. All right, you're all set, Mr. Gossett. Thank you.
What does that even mean?
You're all set. All right, see you in a bit, counsel. Good morning, Detective Beasley. Can you hear me?
Yeah, I can. Can you hear me?
Yes. Calling prosecutor order number 24-17144, State of Michigan versus Frederick Alexander Lindsay. Word is alleged on or about May 26, 2024 in the city of Oak Park. The accused did commit the offense of breaking and entering a building with intent. Detective, please state your name for the record.
Detective Brian Beasley.
All right, do you solemnly swear from the testimony you're about to give us to the best of your knowledge, information, and belief?
I do.
Please proceed with the facts established probable cause.
On May 26, 2024, at approximately 5:08 a.m., Oak Park officers were dispatched to 21830 Greenfield Road, Suite 101, which is T-Mobile in the city of Oak Park. Officers responded to that location, observed the front door to the business to be smashed out. Officers made entry into the store and noticed the drawers and register on the ground. The entire store was ransacked. Officers were notified by dispatch that a cell phone that should have been in the store was being GPS tracked by the owners, and it was on Greenfield near 8 Mile Road, which is just south of this location. Dispatch also notified officers that Michigan State Police had stopped a subject carrying a box of phones near Greenfield and 8 Mile. Officer Harper made that location, spoke with who was later identified as Frederick Lindsay. Mr. Lindsay was carrying a box which contained several cell phones in their boxes, a laptop, and some cords for some phones and the laptop. Officers on scene made contact with the owner who arrived of the T-Mobile. They watched the security camera and they were able to identify Mr. Lindsay as the subject who broke out the front glass door, entered the business and ransacked, and ultimately stealing the cell phones and laptop that were found in his possession down the street. Mr. Lindsay was taken into custody and transported to the station. I ask that you sign the warrant and authorize the claim.
The court finds that the crime was committed. There's probable cause to believe the defendant committed it. I'll not be setting interim bond. Regarding bond in this matter, my inclination is to set like a high bond with 10% provision and a GPS. What are your thoughts with respect to bond?
With respect to bond, I request a high cash bond, no 10%. Mr. Lindsay is homeless. He has no cell phone. He has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 prior convictions for breaking and entering. He also has an LFA and the home invasion is included in that. He is currently on parole for the 2020 B&E out of the Sixth Circuit Court. He is in violation of his parole. He is an absconder. He does have an MDOC warrant and a hold for him. That's why I would request a high cash bond.
All right. So when you say high cash bond, what would you think? What would you recommend?
25,000.
Okay. All right. Very well. Thank you very much, Detective. I'll be arraigning Mr. Lindsay in a few minutes.
Okay. Thank you so much. Have a good. I'll see you a little bit later. I have another one.
Oh, all right. See you later then. Bye.
Okay. Thanks. Bye.
Hey, Mr. Mahikian, can you hear me?
Yes.
And sir, are you Mr. Lindsay?
Yes, I am.
Okay, very well. Calling case number 24-17144, people of the state of Michigan versus Frederick Lindsay. Mr. Lindsay, you've identified yourself. Counsel, please put your appearance on the record. How would you like to proceed?
Good morning, Your Honor. William Hickey, P81520 on behalf of Mr. Lindsay, who is present via video. I have had the opportunity to speak with my client. I've gone over the charge at this waive a formal reading of that charge. He'd stand mute, ask that the court enter a plea of not guilty on his behalf. I would ask for the opportunity to address bond.
All right. Does your client wish to avail himself of a court-appointed attorney?
Yes, Your Honor.
And based on your conversations with him, would he appear to qualify?
Yes, he's currently homeless. He hasn't worked in approximately 2 years.
Alrighty. I'll enter not guilty plea for purposes of arraignment. I'll advise Mr. Lindsay is presumed innocent until proven guilty beyond a reasonable doubt. He has the right to a preliminary examination in 21 days where the prosecutor must establish that this crime was committed and there's probable cause to believe he committed it. He's got the right to try the matter by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford one, court will appoint one, and court intends to do so in this matter. Do you understand all that, Mr. Lindsay?
Yes, I do.
Okay, Mr. Mahikian, you may address bond.
Thank you, Your Honor. My client's 53 years old. As I stated, he is homeless, last working about 2 years ago. I would be requesting initially a personal bond in this matter. As stated, my client's indigent. He's homeless. He doesn't have any money for bond. He has informed me that he plans on taking care of these charges. He doesn't want anything sitting over his head. He doesn't want to be picked up on a warrant. So he does want to resolve this, and knowing that he doesn't have money for bond, any monetary bond would essentially be a detainer. There is a double presumption against monetary bonds in Michigan. I would ask for a personal bond. If the court's unwilling, I'd ask for a low cash bond, just knowing that my client's not going to be able to afford it anyway. But to ensure he gets credit, if the court's not willing to give him a personal bond, we would ask for a low cash bond so he gets credit for the time he sits in jail.
All All right, I appreciate the request. In reviewing the record, it appears though Mr. Lindsay has somewhere in the neighborhood of 10 to 12 prior breaking and enterings. He's currently under supervision of the Sixth Circuit Court at the time of this occurrence. So to ensure defendant's appearance and the safety of the public, the court's going to set bond in the amount of $25,000 cash surety, no 10%, with the condition that Mr. Lindsay not return to 21830 Greenfield in Oak Park or any T-Mobile location. They appear for any court proceeding. They did not leave the state without permission of the court. They notify the court in writing immediately of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, non-recreational marijuana, or illegal drugs. No new criminal offenses will be supervised by pretrial services, who he must contact within 24 hours of his release, and he must be fitted with a GPS tether prior to release that would allow him to go to medical appointments in court. His next court date is a probable cause conference set for June 3rd at 9 a.m. His exam is set for June 10th at 9 a.m. Both of those at the Oak Park District Court. All right, Mr. Lindsay, you're all set. Good luck to you.
Thank you, Your Honor.
Thank you both. Thank you both.
Thank you,
All
Mr.
right.
Oh, I do.
Oh, yeah.
Copy.
All right, are you Amanda McAleer?
Yes.
All right. Calling case number 24MI00419, people of the Village of Milford versus Amanda McAleer. Ma'am, you've identified yourself. Counsel, please put your appearance on the record. How'd like to proceed?
Good morning, Your Honor. Will Hickey, P1520 on behalf of Ms. McAleer, who is present via video. I have had the opportunity to speak with my client. I've gone over the charges. At this time, she'd waive a formal reading of those charges. She'd stand mute, ask that the court enter a plea of not guilty on her behalf. I would ask for the opportunity to address bond.
All right, does Ms. McAleer desire to use the services of a court-appointed attorney, or will she be retaining counsel?
I believe she's initially going to ask for appointed attorney, and then if she wants to, she can hire her own. Ms. McAleer, how often do you work?
I work part-time, but actually I was going to get my own attorney.
Okay, so you're going to retain counsel?
Yeah, I actually have an attorney currently, so
All right,
I'll just.
All right, ready? I'll enter a not guilty plea for purposes of arraignment on defendant's behalf. I'll advise her she's presumed innocent until proven guilty beyond a reasonable doubt. She's got the right to try the matter by judge or jury. She's got the right to remain silent. That silence cannot be used against her, and she's got the right to be represented by an attorney if she cannot afford one. The court will appoint one for her. It appears she's retaining counsel in this matter. With respect to bond, counsel, the court is usually very concerned when there's some allegation of disobeying law enforcement or resisting or something of that nature, that the defendant's going to appear voluntarily, but I'll listen to your argument with respect to bond.
Oh, I think there's a detective there if he wants to address bond first.
Your Honor,
Detective,
Sergeant. Good morning, Your
Go
Honor.
ahead.
Sergeant Caldwell, Milford Police Department. Discretion of the court on bond, Your Honor.
All right, thank you. Mr. Nahikian, you may address bond.
Thank you, Your Honor. My client's 48 years old. She does work full-time. This was an incident that she doesn't believe she assaulted anyone in, and it was involving her son and husband. They are technically going through a divorce. They're separated, so there may be reasons for one party to make allegations at this point. But we are perfectly fine with a no contact order, even a no contact order with her son at this point. It's my understanding the resisting obstructing relates to her refusal to do fingerprints. So I don't think that should really play a huge role here, especially if she's willing to get fingerprinted before getting released, which I'm fine adding that as a condition of her bond. But I would be asking for a personal bond with a no contact order if necessary. My client has a limited criminal history. I think her last charge was an OWI when she was in college. There may be things I don't know about because I don't get a full criminal history, but these are misdemeanors I do believe a personal bond would be appropriate. There's nothing to suggest she's a danger to the public, that she would be a flight risk. She wants to resolve this case. As she stated, she already has her own attorney. So I would be asking for a personal bond with conditions, Your Honor.
All right, I appreciate the argument. Court's concerned that defense voluntarily going to appear whenever there's a problem with respect to obeying law enforcement, getting booked, fingerprinted, following instructions. Maybe that, I don't know if there's, I think there's also some information regarding substance use, a prior drunk driving or something like that. So I don't know if that played a part in this or not. But to guarantee defendant's appearance, court's going to set bond in the amount of $5,000 cash surety or 10%, with the condition that Ms. McAleer not have any contact with Stephen or Nicholas McAleer. And then detective, does everybody reside?
Yes, Your Honor.
Not to return to return one time with the police escort to retrieve her personal items. She must not harass or intimidate any witness. She must appear for any court proceeding, not leave the state without permission of the court. Merely notify the court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons. Refrain from using any alcohol, non-prescribed marijuana, or illegal drugs. She'll test one time a week randomly for alcohol and drugs through the 52 bond compliance program, who she must contact within 24 hours of her release. She'll be given their contact information and not commit any more crimes. All right, do you understand all that, Ms. McAleer?
Yeah, I did get fingerprinted though.
All right, you're all set. Thank you very much.
Thank you, Your Honor.
Yeah.